Hello friends, today I am taking important questions and answers from Family Law 1. First, the question number 1. Discuss in brief sources of Hindu law. Define custom as a source of law. So, Hindu law is derived from two types of sources. One is ancient sources and second is modern sources. Now, ancient sources. These are traditional and primary sources. Shruti, the Vedas considered as divine revelation and of the highest authority. Smriti, texts written by sages explaining Shruti, that is Manusmriti, Yajnavalakya Smriti, commentaries and digests, scholarly explanations of Smritis. They developed different schools like Mitakshara and Dayabhag. Custom based on usage, practices followed continuously by a community accepted as binding. Now second is modern sources. These include legislation, acts passed by the parliament like the Hindu Marriage Act, Hindu Succession Act, etc. Judicial decision, precedent, decisions of court that guide future cases. Justice, equity and good conscience applied when no specific law exists. Judges decide based on fairness. Now definition of custom as a source of law. Custom is a long established practice continuously followed by a community which has gained the force of law because people regard it as binding. Now what are the essential features of a valid custom? It is ancient, followed since a long time, continuous and uniform, certain and not vague, not opposed to morality or public policy. So custom is an old and accepted practice that becomes law because people treat it as obligatory. Now question number 2. Hindu marriage is a sacrament. Discuss in detail. The answer will be under traditional Hindu law, marriage, vivah, is regarded not as a mere contract but as a sacred and religious sacrament. The concept of marriage in Hinduism is deeply rooted in spiritual values, religious duties, and the continuation of family lineage. Hindu marriage is considered as sacrament because of the following reasons. Number one, religious and spiritual foundation. Marriage is one of the 16 sanskars, sacraments in Hindu life. Rituals like Saptapadi, 7 steps or Satfere, and home are performed with fire as witness, invoking sacred vows in front of deities. The purpose is not just championship but spiritual upliftment and fulfillment of dharma, religious and social duties. So this is about religious and spiritual foundations. Now second is permanent and unbreakable bond. So traditionally Hindu marriage was considered permanent and unbreakable. The couple is believed to be bound for this life and beyond, 7 lives. There was no concept of divorce in ancient Hindu law. Third is union of families and souls. So marriage is union of families and souls. Marriage is not just between two individuals, but a union of two families, cultures, and lineages. The couple becomes one unit, performing religious duties together. After codification through the Hindu Marriage Act 1955, marriage still carries sacramental elements but with modern features. Ceremonial requirement. Marriage must be performed with custom and ceremonies like Saptapadi. Without ritual, the marriage is not valid as per section 7. Indissolubility modified. Divorce is now legally permitted under section 13 and 13b. So while the spiritual idea remains, legally marriage can be dissolved. Now, next is consent and equality. Marriage now requires free consent, soundness of mind, and lawful lawful age as under Section 5 of this Act. Thus, in modern law, Hindu marriage is considered both as a sacrament and a social or legal contract, but the sacramental nature still dominates its essence. Question number 3. What are the essentials of a valid Hindu marriage? Explain grounds of divorce under Hindu Marriage Act. Also explain restitution of conjugal rights. The answer will be essentials of a valid Hindu marriage. This comes under Section 5 and 7 of Hindu Marriage Act 1955. Now, monogamy. It comes under Section 5(1). Neither party should have a living spouse at the time of marriage. Second, sound mind. Section 5(2). Parties must be capable of giving valid consent and not suffering from mental disorder. Age. Section 5(3). Bridegroom age 21 years and bride age shall be 18 years. Prohibited relationship. It is under Section 5(4). Parties not within prohibited relationship unless permitted by custom. Subpoena relationship. Section 5(5). Parties not subpoenas of each other unless custom allows. Subpoena means persons related with certain generations, usually within 3 generations on the mother's side and 5 on the father's side. Ceremony. Section 7. Marriage must be solemnized as per customary rites. That is Saptapati, 7 steps of Sat Phere. Now, what are the grounds for divorce? It comes under Section 30 Hindu Marriage Act 1955. So, common grounds for both husband and wife. Adultery, voluntary sexual intercourse with another person. Cruelty, physical or mental cruelty. Desertion, continuous desertion for 2 years. Conversion, cease to be Hindu. Unsound mind, mental disorder making life with respondent unreasonable. Vulnerable disease, incommunicable form. Renunciation, not hard for entered religious order, presumed dead, not heard for last 7 years. Judicial separation. Section 10 says allowing parties to live apart without dissolving the marriage. So, according to Section 10, parties can live apart without dissolving the marriage. Additional grounds for wife comes under Section 13(2). Husband has another wife living at the time of marriage. Husband guilty of rape, sodomy or bestiality. No cohabitation after decree for maintenance or judicial separation for 1 year. Married before 15 and repudiated marriage before 18. Now, restitution of conjugal rights. Under Section 9, either spouse can file petition in the court to compel the other to resume cohabitation if one has withdrawn without reasonable cause. Now, question 4. Discuss the circumstances under which a Hindu wife can live separately without forfeiting her rights of maintenance. The answer will be right of a Hindu wife to live separately without losing maintenance comes under Section 18(2) of the Hindu Adoption and Maintenance Act 1956. A Hindu wife is entitled to live separately from her husband without forfeiting her right to maintenance if any of the following circumstances exist. Number 1, desertion. If the husband deserts her without reasonable cause and against her will. Cruelty. If the husband treats her with cruelty, physical or mental, making it unsafe or undesirable to live with him. Case law NG Dastane versus S. Dastane 1975. Cruelty includes mental sufferings. Leprosy. If the husband is suffering from a virulent form of leprosy. Although leprosy is no longer a ground for divorce, it still appears under Section 18(2) unless amended. Another wife. If the husband has another wife living or keeps a concubine in the same house or habitually resides with her elsewhere. Conversion. If the husband has ceased to be Hindu by converting to another religion. Any other justifiable cause. If there is any other reasonable cause for her to live separately. Example. Husband neglects or refuses to maintain her or makes her life miserable due to bad conduct, drunkenness, nest, etc. Note, under section 18(3), a wife is not entitled to maintenance if she is unchaste, Bajjalan, or converts from Hinduism. Now question 5. Muslim marriage is monogamy as a rule and polygamy as an exception. Explain. The answer is, in Muslim law, marriage, nikah, is a civil contract. Islam permits a man to marry up to 4 wives, but only under a strict condition laid down in the Quran. If you cannot do justice, then marry only one. This shows that monogamy is the general rule because doing equal justice among wives in matters of love, maintenance, and treatment is difficult. Polygamy is allowed only in exceptional circumstances, such as welfare of widows or orphans, and even then only when true equality can be maintained. Thus, Islam does not encourage polygamy, it only regulates it. Question number 6. A mother can be a legal guardian of minor's property under Muslim law. Explain the law. Under traditional Muslim law, the mother is not the natural guardian of the minor's property. The father is the primary natural guardian, and after him the guardianship passes to other male relatives in a specific order. Mother is not considered as a legal guardian of property, though she is the custodian of the child, hijanat, meaning she has the right to the physical custody of minor child. However, the position changed after the enactment of the Guardians and Wards Act 1890 and through court's decision. The act empowers the court to appoint the mother as guardian of the property of the minor if it is in the welfare of the child. If the welfare of the minor is the paramount consideration in this case. If the father is unfit, absent, negligent, or dead, the court can appoint the mother as a legal guardian of the property. Case law. Mambandi versus Budsaddi 1918. Mother is not natural guardian under Muslim personal law, but under Guardians and Wards Act 1890, court can appoint mother as the guardian. Hence, a mother can become a legal guardian of the minor's property, but only by court's appointment, not by personal law. And the last question is, define nikah. Is it a contract? Discuss in detail. Answer is, the term nikah literally means union, tie, or contract of marriage. In Islamic law, nikah is a legal and social contract between a man and woman for the purpose of legitimizing sexual relations and procreation of children. According to Amir Ali, marriage, nikah, among Muslims is a civil contract, the object of which is the legalization of sexual intercourse and the procreation of children. Is nikah a contract? Yes, nikah is a contract under Muslim law. Although it has religious significance, it is essentially a civil contract having legal consequences. Essential features showing nikah is a contract. Number 1. Offer and acceptance. Ijab and Kabul. One party makes an offer, ijab, and the other accepts, Kabul. It is in the same meaning. Free consent of both the parties is essential. Example, the guardian or parties themselves declare offer and acceptance before witnesses. Competent parties. Both parties must be Muslims of sound mind and have attained puberty, usually presumed at age 15. Consent under coercion, fraud, or mistake is invalid. Presence of witnesses. For a Sunni marriage, presence of 2 male or 1 male and 2 female witnesses is required. Under Shia law, witnesses are not mandatory but desirable. Dower, mahar. Mahar is an essential element of nikah. It is consideration for the marriage. It may be prompt or deferred. This monetary aspect supports the contractual nature of marriage. Capacity and prohibitions. The parties must not be within prohibited degrees of relationship. Consanguinity, affinity, fosterage. Such marriages are void. Batil. Registration is optional. Though not essential under classical Muslim law, registration is often required under modern statutes for evidentiary purposes. So this is about all about important questions of family law. Thanks for watching this video, friends. Do subscribe my channel.